Hello and welcome to our live Supreme Court Roundup webcast presented by Gibson Dunn. I'm Noreen with the Gibson Dunn team. Before we get started, I wanted to go over some housekeeping items. If you have any questions for our panelists, we invite you to submit your questions through the Q&A box inside the virtual attendee hub. Please make sure to include your first and last name, and we will answer the questions at the end of the program, or a panelist will reach out to you individually to answer your question. In regards to MCLE credit, the webcast is approved for 1 hour of credit. Copies of the presentation materials and CLE forms are available to download in the CVent virtual attendee hub. Please note that you will need to include a passcode for each session you attend on your MCLE form in order to claim credit. There is a unique 4-digit code for each session and it must be included on the form. Please make sure to listen to the code as it is announced during the program. Once you have completed the form, including your passcodes and your license information, please submit the form to cle@gibsondunn.com. Now I will turn it over to Lauren Blass and Blaine Evison, today's presenters.
Well, good afternoon, everyone, and welcome to our annual Supreme Court Roundup. My name is Blaine Evison, and I'm joined by my partner, Lauren Blass. Lauren is resident in our Los Angeles office, and I am in the Irvine office. We both practice in the appellate and constitutional law practice group, as well as in class actions, labor and employment, and other areas, both in the trial court and on appeal.
Thanks, Blaine. And just to give a quick overview of what we'll be covering today. So the first part of our presentation will go over some stats and trends from the court's last term. Then we'll talk a little bit about the recent members of the court and some interesting trends in their jurisprudence. We'll do a sort of a quick hit from some of the cases from last term, which many of you may be familiar already, but are worth a brief mention. And then we will go in depth through a couple of interesting cases that have either already been argued this term or that will be coming up in the next couple of months. As Noreen said, we're happy to answer questions. You can put them in the Zoom chat. If we see them in time, we'll try to answer them on the fly. And if not, we'll try to get them at the end or follow up with you individually. I think we can go on to the next slide, Jen. So as a starting point for our discussion, we thought we'd take a look at the court's caseload. So as you can see, the court's caseload continues to decrease, and the court has exercised increasing discretion in choosing the cases that it will hear. The past decade has seen the court hover around 70 to 80 cases per term out of about 7,000 to 8,000 petitions for certiorari that it gets. So that's about 1% of the cases it actually hears compared to the petitions it receives. And that's, as you can see, down from historical numbers. There are multiple reasons that are given for the reduction in the court's docket. For one, historically, much of the court's jurisdiction has been mandatory, but that was largely eliminated by Congress back in the 1980s. And there's really only 4 main sources of mandatory jurisdiction left. And these are cases where typically a case is heard by a 3-judge panel in the lower courts, and then it's able to be appealed as a matter of right up to the high court. And those tend to be sort of reapportionment challenges, civil rights, voting rights, and sort of FEC related litigation. So very small category of cases now that are subject to mandatory jurisdiction. Similarly, there's a process in the Supreme Court rules that allows for certified questions. In other words, for the Court of Appeals to certify questions up to the Supreme Court for their opinion. But this practice has really been very underutilized despite its prevalence in the rules. There have been only 4 certified question cases since 1946. So what you see today now is mostly all under the court's control and discretion in terms of what it is that they want to hear. Some court watchers also point to the fact that the court hears more complex cases that require more time and attention than they once used to. In the past, the court frequently addressed issues of federal common law, but nowadays, obviously, it decides many complex statutory construction cases and other cases that are complicated by circuit splits. We can go on to the next slide, please. In terms of the pace of grants this term, which we'll call OT20, the pace started off relatively slow compared to recent terms. One imagines that the court's transition to remote work and conferencing, as well as the late end to the 2019 term, may have contributed to the comparatively sluggish pace at the beginning. But coming out of the winter break, though, the court granted a whopping 14 cases, which contained a number of fascinating matters, including 2 First Amendment cases that we'll address a little later on in the presentation. So far this year, the court has been most active in granting cases from the 5th and 9th circuits, which is consistent with last term, which saw the court reversing those circuits at a higher rate as compared to the others. And you can see the reversal rates, or I'm sorry, those are the cert grant rates there on the right. Next slide, please. Moving on to discuss interesting nexuses of agreement among the justices. So the court in 2019, during the 2019 term, I should say, featured 2 prominent, what we'll call dyads on each wing. There's Chief Justice Roberts and Justice Kavanaugh on one side, and Justice Ginsburg and Breyer on the other. Each of those dyads ended up on the same side 93% of the time if you look at all cases, and 90% of the time in divided cases, meaning those in which at least one justice dissented. So not necessarily 5-4, but at least one dissent. By contrast, the lowest rates of agreement were between Justice Sotomayor on the one hand, and Justice Alito and Thomas on the other. They were on the same side, less than 20% of divided cases. Justice Gorsuch continues a recent trend of having relatively lower and more varied rates of agreement. That's one difference between him and Justice Kavanaugh, who's been more reliably aligned with the Chief Justice across different categories of cases. Notably, neither Chief Justice Roberts nor Justice Kavanaugh appears anywhere on the lowest agreement list on the right side of the slide. This underscores the Chief's role as a consensus builder and the 2 new justices, those 2 justices' central position on the court. These agreement ranges that are listed here have been relatively consistent over the past few years. Next slide, please. Moving on to discuss 5-4 decisions. So there was a slight downtick in the number, which was somewhat interesting given that in many observers' views, the last term contained many more controversial and hot button cases as compared to the term before, and we'll talk about a few of those in a few slides. Some have suggested that the heightened public scrutiny of the court, whether as a consequence of the recent very high-profile confirmation battles or the 2020 election, produced a greater number of dispositions that were based on compromises or were less controversial and sort of had more of a proceduralist angle as opposed to tackling the thornier and more complicated issues. It remains to be seen, of course, whether calls for court reform in the next Congress will encourage similar moderation this term. It will be an interesting topic of discussion for next year's presentation. You'll see in the data there's an interesting blip in 2015 and 2016 in terms of 5-4 decisions. The historical average, as you see, is around 21%, but those 2 years we had a much lower percentage of divided cases, and that is largely attributable to the fact that the court was missing a justice for much of that term. Next slide, please. So continuing to talk about membership in these 5-4 decisions. So the 2018 term was one of the most balanced terms in recent memory. So as you can see, most of the justices were in the majority at roughly equal percentages of the time. But the statistics from last term, and that's the frequency in the majority column on the slide, suggest that the 2018 term was likely a blip, as the conservative wing, as you can see, has enjoyed a substantial, though not universal, command of closely decided cases. Chief Justice Roberts, as we've seen, was by far the most likely member of the 5-4 majority, followed in quick succession by Justices Gorsuch and Kavanaugh. Ginsburg and Breyer, conversely, were in the majority of 5-4 decisions just over 20% of the time. So obviously an interesting shift here in terms of the progression of the slowly consolidating power, I guess, of the more, quote, conservative wing of the court. You can see that Justice Roberts, as just one example, was in the majority only at 25% of the time 5 years ago, but has really moved to the center and been sort of in the thick of things far more often in the recent terms. Gorsuch, though, interestingly, has sort of had high percentages throughout his time on the court. It'll be interesting to see if that continues, and Blaine may shed some more light on that when he talks about some things we've noticed about the new justices. Next slide, please. So in terms of reversal rates from last term, so these were fairly high across the board. It's often said that more often than not, the court grants certiorari in cases to reverse, and that was certainly true in the last term when the court reversed in over 2/3 of its cases. The highest reversal rates, excluding the First and Seventh Circuits, each of which had only one case go up to the court, went to the Fifth and Ninth Circuits. The Ninth Circuit is sort of a classic example. It gets beaten up on a lot in term by the Supreme Court, and there's a perception certainly that the Ninth Circuit is really out of step with the Supreme Court. But the Fifth Circuit has the opposite reputation as being one of the more conservative circuits. So it's been interesting to see that those are the two sort of getting reversed the most often. And then as a sort of a side note, the court also reversed in about 70% of cases that have come up through state Supreme Courts. Next slide, please.
Okay. As I'm sure everyone knows, President Trump's first two appointees to the Supreme Court were Neil Gorsuch and Brett Kavanaugh. Justice Gorsuch joined the court in April 2017 to replace Justice Antonin Scalia, and Justice Kavanaugh joined the court in October 18 to replace Justice Anthony Kennedy. And both justices are cut from the same overall cloth. They both are longtime members of the conservative legal establishment, both worked in the executive branch in the George W. Bush administration, Justice Gorsuch in the Justice Department and Justice Kavanaugh in the White House. And they both are characterized as conservative justices on the Supreme Court. They vote most frequently with each other and with the Chief Justice. And before Justice Kennedy retired, we all looked at the court as, generally speaking, a 5-4 court, sometimes liberal, sometimes conservative, but with Justice Kennedy almost always in the middle. And if the case was a close case, then the question was really which of the blocks Justice Kennedy would vote with. He was more liberal on gay rights and marriage equality and reproductive rights and the death penalty, but he was conservative on issues of federalism and most business cases and most criminal justice issues. And on the First Amendment, he was always for expanding protections, no matter the context. So, but always depending on the issue in the case, it was generally fairly easy to tell which way the 5-4 majority would go, because Justice Kennedy was almost always in the majority in those cases and had a very eclectic but well-defined legal philosophy. Replacing Justice Kennedy with Justice Kavanaugh was not really an even trade, because Justice Kavanaugh is generally more conservative than Justice Kennedy and more of a traditional conservative. So the effect of replacing Justice Kennedy with Justice Kavanaugh has been to push the Chief Justice into the median role and shift the overall center of the court to the right. And for a few terms, the Chief Justice really reigned in that role as the median justice. Last term, as Lauren mentioned, he was in 93% of the 5-4 cases, and he was in the majority overall 97% of the time. He was dubbed the anchor justice rather than the swing justice, because he anchored majorities, again, in almost every case. And until Justice Amy Coney Barrett joined the court this term, many court analysts were describing a new moderate majority on the court, made up of the Chief Justice, Justices Breyer and Kagan, and Justices Gorsuch and Kavanaugh. Justices Ginsburg and Sotomayor generally vote to the left of their less liberal Democratic appointees, and Justices Thomas and Alito generally vote to the right of their less conservative Republican appointees. So in the 2019 term, last term, there were several 7-2 splits, including in some really divisive cases like the Trump tax return cases, where Justices Thomas and Alito dissented, but all seven other justices voted with the majority and generally against the president. And in two key religion cases, Justices Ginsburg and Sotomayor were in dissent, voting against the other 7 justices for expansive religious liberty protections. So the court had shifted from the Kennedy court to the Roberts court. And when there were 5-4 cases, there has been a surprising diversity in the makeup of those 5-4 lineups. In the 2018 term, for example, you had every one of the Republican appointees join the 4 Democratic appointees in at least one case to form a 5-4 majority. Justice Gorsuch has joined the liberal bloc of the court in some really important cases on criminal justice, tribal rights, and civil rights. He wrote the opinion for the court last term, holding that Title VII prevents discrimination against gay or transgender employees. So the bottom line is that the ideology of the court has become much more complicated since Justice Kennedy's retirement. And people like to say we have a new long-lasting conservative majority, and that's certainly true in some sense. But it's also a little more complicated than that. Next slide, please. But Justice Ginsburg's passing last September brought an incredible shakeup in the court's ideology. And before we talk about Justice Barrett and the changes to the court, I think it's important to pause and acknowledge Justice Ruth Bader Ginsburg's remarkable legacy on the court and in life. She was a true pioneer in the profession. She was one of just a few women in her law school class. She was reportedly rejected for a Supreme Court clerkship due to her gender and narrowly received a district court clerkship when, again, reportedly one of her law professors threatened this particular judge that he would never send her another student if the judge didn't hire Ruth Bader Ginsburg. And throughout her academic and civil rights litigation career, she made an enormous impact in the area of gender equality. She litigated some of the most important cases that laid the groundwork for equal protection extending to gender equality. And so she joins Thurgood Marshall as a justice whose status in the American legal pantheon was settled even before she took the bench. In her confirmation hearings, she affirmed deep beliefs in the right to privacy and gender equality in ways we don't see candidates today be as forthcoming. She was an unabashed progressive, yet she was confirmed by a 96-3 vote because people recognized what a truly remarkable lawyer and by that point, DC Circuit judge she had been. As a justice, her most notable decision, the most notable decision she authored was probably the 1996 Vmi decision, which recognized that the Constitution demands an exceedingly persuasive justification before government can discriminate on the basis of sex. But besides the Vmi decision, most of the impactful majority opinions she authored were in the area of civil procedure. Justice Scalia famously called her a tigress on civil procedure, saying that she had done more to shape the law in this field than any other justice on the court. And she brought clarity to areas of procedure where the court's decisions had been a mess. And if we're talking about just the impact on the jurisprudence of the court, civil procedure is probably where she had the most lasting impact. But her real acclaim and what most people will probably remember her for is her insightful and powerful dissenting opinions. She dissented in a Title VII case called Ledbetter versus Goodyear Tire, and in it called on Congress to amend Title VII. And 2 years later, the Lilly Ledbetter Fair Pay Act became the first enactment signed into law by President Obama. She also dissented in Shelby County versus Holder, and her opinion was so powerful that it prompted her nickname as the notorious RGB, a nickname that will stick around for eternity, I suspect. In another era, she may have written the opinions clarifying the scope of reproductive rights, but she served on a court that has largely been scaling back the right recognized in Roe versus Wade. So she found herself in dissent a lot. And in other areas like gay rights and marriage equality, she was the junior justice to Anthony Kennedy. And so she found herself joining his majority opinions rather than writing her own. But she is for sure an icon in the history of the court. Next slide, please. Justice Ginsburg's replacement, you all know, is Justice Amy Coney Barrett. And Justice Barrett joined the court just this past October after having been a judge on the Seventh Circuit. She was also nominated by President Trump to the Seventh Circuit. She is a former clerk to Justice Antonin Scalia, and she was a law professor at the Notre Dame Law School. And she, due to her relatively brief tenure On the Court of Appeals, there's not a great deal to glean from her official opinion record that helps predict how she will be as a justice. But she is a committed textualist and originalist, and she cements a pretty solid conservative majority on the court. She has been resistant to claims that she will decide every case just the way Justice Scalia would. And as we have seen the past few terms, with disagreements among the Republican appointed justices, originalists and textualists don't always agree. But she unquestionably shifts the court to the right, especially when you look at who she replaced. Justice Gorsuch replaced Justice Scalia, and that is a relatively even trade. Justice Kavanaugh replaced Justice Kennedy, and with the caveats I mentioned earlier, that is a relatively even trade. But Justice Barrett is replacing one of the more progressive justices on the court in our generation, and so she unquestionably shifts the court to the right. And she's only been on the court a few months and is not taking part in the cases that were argued before she took the bench. But we've already seen an impact in the form of her first publicly discernible vote, which was in a case called Brooklyn Diocese versus Cuomo, which we'll talk about later on. Next slide, please. The last feature of the court we want to discuss before getting to the merits cases is what's been dubbed the Shadow Docket. In addition to its docket of cases on which the court grants certiorari to review merits decisions of the lower federal courts and state Supreme Courts, is requests for relief from the court itself, including stays of district court decisions, injunctions pending appeal, certiorari for judgment, and requests and similar requests. And the shadow docket is obviously not an official term. It's not written in the rules, but it's what a law professor named this part of the court's docket, and the name has stuck. And they're not great statistics on the shadow docket, but under any measure, there has been a huge increase in the activity on this docket in recent years, including some decisions that have been enormously impactful. And the net effect is that some of the Supreme Court's most consequential decisions have not come through the traditional path where they've been briefed and decided in the district court, briefed and decided in the courts of appeals, and then briefed both at the certiorari stage and on the merit stage, and then at oral argument in the Supreme Court. That process that we are generally used to takes multiple years to get from a district court up to the Supreme Court. But these shadow docket decisions have been made on the papers on a much more compressed schedule. And a large portion of this docket has been administered by the Solicitor General's office that has defended the Trump administration. And to take just one example, during the 16 years of the George W. Bush and Obama administrations, the Solicitor General filed a total of 8 stay applications, emergency stay applications, averaging 1 every other term. And during the first 3.5 years of the Trump administration, they filed 36. And looking at the court's rulings on the Solicitor General's stay applications, the SG hasn't won all of them, but he's done very well. They've won full or partial relief in 23 out of 36 cases. And that's a better percentage than 4 out of 8 during the Bush and Obama years. And the net effect of the court's actions in most of these cases has been that the Solicitor General has gotten most of what he asked for, generally leaving the specific federal policy under challenge in place pending the full course of the appellate litigation. And some have accused the Solicitor General of abusing this process. Others put the blame on district judges for issuing broad universal injunctions on Trump administration policies. Others put the blame on the president for those policies that are enjoyed. So it's a bit of a Rorschach test, who you blame or credit, but there's no question that this is a growing area of the Supreme Court's docket. And just to cite a few examples of the court's rulings in the past few years, the justices cleared the way for 3 federal executions, allowed President Trump to use military construction funds to complete the border wall, They pushed back resolution of a dispute between the House of Representatives and the Justice Department over the Mueller report. And then just last week, the court overruled a federal district judge that had blocked the FDA's in-person distribution requirement for the RU486 abortion pill. There have been many rulings related to COVID-19. The justices froze a district court order that had required an Orange County jail to protect inmates from an outbreak of COVID-19. The court blocked Governor Cuomo's restrictions on places of worship in New York. The court declined to interfere with a Pennsylvania Supreme Court ruling that had upheld business closure orders by the governor. And then there were a whole host of rulings related to the election. And there the court declined to get involved when even when the states were pretty significantly changing their election procedures. But there were dozens and dozens of motions and requests and petitions that went to the Supreme Court during the lead up to and after the election. Next slide, please. Returning to the merits docket, here's a quick overview looking back at the court's 2019 term. There were a huge number of blockbuster decisions actually in this term, and I'll just touch base on them briefly before we move to this term. Bostock was a Title VII case in which the court held that an employer who fires an individual merely for being gay or transgender violates Title VII of the Civil Rights Act. June Medical Services struck down Louisiana's Unsafe Abortion Protection Act, which had required doctors who perform abortions to have admitting privileges at a nearby hospital. Trump versus Vance was a grand jury subpoena seeking the president's financial papers and his tax returns. And the court held that Article 2 and the Supremacy Clause do not categorically preclude the subpoena. And so the issuance of this and remanding for the court to consider whether to issue the state criminal subpoena. Trump versus Mazars involved congressional subpoenas for the president's information, and the court held there that such subpoenas may be enforceable, but that the lower courts did not take account of the significant separation of powers concerns implied by the subpoenas. DHS versus Regents involved the Deferred Action for Childhood Arrivals program, known as DACA, and the court held that the Department of Homeland Security's decision to rescind the program was arbitrary and capricious under the Administrative Procedure Act. Espinoza involved what's called a Blaine Amendment, which prohibited indirect or direct funding of religious schools, and the Supreme Court struck down Montana's amendment as violating the Free Exercise Clause. And finally, Celia Law versus CFPB, the court there held that the Consumer Financial Protection Bureau's leadership by a single director removable only for inefficiency, neglect, or malfeasance violates the separation of powers. So that was October 2019 term, the quick and dirty overview.
Okay, so next slide, please. So in the next section of our presentation, we're going to go through a couple of the highlights so far from the 2020 term. So we'll talk briefly about an election law, shadow docket matter, a couple of healthcare cases, religious liberty case, First Amendment cases that were just recently granted a few weeks ago. Next slide, please. A few cases involving corporate liability, one under the Alien Tort Statute and another an important class action decision. We'll talk briefly about an upcoming antitrust case and hit on an admin law matter as well. Next slide, please. So first up, and before I go any further, I wanted to provide the MCLE code for the presentation, which you'll need to record on your form to get credit. The code is 0931. Again, the code is 0931. Okay, so on to Democratic DNC versus Wisconsin State Legislature. So the court did not hear any arguments in election cases this fall, but it handled several challenges to state election laws and procedures on its shadow docket, as Blaine was just describing. One such challenge, of course, and many of you may be familiar with this matter, but we thought we would highlight it just in case, was this DNC versus Wisconsin State Legislature case, which considered whether the deadline for absentee voters to mail in their election ballots could be extended for COVID-19. Spoiler alert, the court denied the Wisconsin Democrats' request. What is most notable about the decision is not really the decision itself, but the concurrences and sort of additional opinions that accompanied the denial. So in a concurrence, Justice Gorsuch had a separate concurrence, and then Justice Kavanaugh had a longer one, in which he authored a long footnote expressing support for what's called the Independent State Legislature Doctrine. This doctrine states that under Article 2, Section 1, federal courts may intervene on matters of state election law, and state legislatures, not state courts or governors, have the authority to set the rules for federal elections. This principle had been articulated in Bush versus Gore in a concurrence from Chief Justice Rehnquist, which was joined by Scalia and Thomas. Bush v. Gore, until this point, had famously been cited only once, ever, in a dissent by Justice Thomas, but Justice Kavanaugh cited it here as, quote, persuasive on the issue of the independent state legislature doctrine. It seems like Justice Kavanaugh is not alone in his views on this. Justice Thomas, Gorsuch, and Alito have already shown some sympathy towards this doctrine, and we may start seeing it in more election cases. This election cycle, for folks that have been following it, there were a number of cases in which a state legislature disagreed with its state Supreme Court's interpretation of state election law, although ironically, this was not one of those cases. But in objecting to certification, several members of Congress pointed to Article 2, Section 1 as the reason for doing so, citing states like Pennsylvania, where the Republican state legislature disagreed with the interpretation of state election law by the majority Democrat-appointed Pennsylvania Supreme Court. Justice Kavanaugh's concurrence in the DNC case also raises the specter of federal court intervention where a state governor and a state legislature disagree. Most recently, the Supreme Court in the Arizona State Legislature versus Arizona Independent Redistricting Commission case, this is a 2015 case, held that the word legislature should be read, quote, in accordance with the state's prescriptions for lawmaking, which may include the referendum and the governor's veto. Under Justice Kavanaugh's view, this may not be correct. Theoretically, a state law passed by the legislature but vetoed by the governor might be upheld by a federal court under Article 2, Section 1. So obviously this was a tremendously eventful election cycle, to put it mildly. It's obviously, though, not the end of election-related litigation, and it may not even be a high watermark. The independent state legislature doctrine that made an appearance in this matter may loom large over future elections, particularly considering that it has the votes of at least 4 current justices and possibly more. Next slide, please. Moving on to discuss a pair of healthcare cases, California versus Texas and Texas versus California. So these cases address the constitutionality of the ACA. So if this feels like Groundhog Day to some folks, it is to some degree. So in 2012, the court found in the Enfib versus Sebelius case that the ACA's individual mandate, i.e. the rule requiring every American to buy health insurance, was constitutional. As a refresher, to reach that decision, the court relied on the fact that the individual mandate was a tax. But in December 2017, Congress reduced the penalty for failing to obtain health insurance from $695 to $0. This in turn prompted a group of states, Republican leaders, and individuals to bring a new constitutional challenge against the ACA. They argued that without a penalty for noncompliance, the mandate is merely a command to buy health insurance and is therefore unconstitutional. And without the mandate, they argue, the rest of the ACA is also invalid. Before the court got into these thorny questions of constitutionality, there was an issue of standing and whether the plaintiffs had a legal right to sue. The individual plaintiffs argued they had standing because they had to spend money nearly every month buying health insurance as required by the mandate. The ACA's defender argued that the individuals did not have standing because the mandate is not a legal command. Even if it were, there was no threat it would be enforced against them because there is no longer a penalty for noncompliance. The state challengers, for their part, argue that they had standing because the mandate increased their costs by requiring people to enroll in Medicaid and increasing the amount of paperwork required by the IRS. Turning to the merits of the case, several justices questioned how the mandate could still be constitutional now that Congress had reduced the penalty for failing to obtain insurance to zero. With the mandate no longer raising revenue, they reasoned, the ACA's defenders were left to rely on the same constitutional provisions that failed to justify the mandate last time. Justice Breyer disagreed, pointing out that many laws include commands like buy war bonds or plant a tree without any enforcement mechanism. In the challenger's view, he wondered, were all of those laws unconstitutional? Justice Kagan also seemed to side with the defenders on this point. After all, how could removing the penalty, which would make the mandate less coercive, transform the mandate into a command? So finally, the justices considered whether the rest of the ACA could survive without the mandate. Several conservative justices seemed skeptical, pointing out that defenders of the ACA back in 2012 also claimed the entire system would fail unless people were compelled to buy insurance. The ACA's defenders responded by arguing there was no sign that Congress wanted the ACA to fall if the mandate were deemed unconstitutional. Many members of the court were not convinced, but Chief Justice Roberts and Justice Kavanaugh seemed to agree, pointing out that Congress chose to amend the ACA to remove the penalty without repealing its other provisions. So the case was argued earlier this year, I think, well, last fall actually, and we should be getting a decision sometime in June. Now I'll turn it over to Blaine to discuss one of the religious liberty cases.
Okay, next slide, please. And a reminder for anyone who missed it, the MCLE code is 0931. That's 0931. So religious liberty has been a major focus of the court's docket the last few years. And I mentioned in my overview of the 2019 term, the Espinoza case. Last term, there was also Our Lady of Guadalupe School versus Morrissey regarding the ministerial exception on the First Amendment. There was also Little Sisters of the Poor, which held that the Department of Health and Human Services had authority to exempt employers with religious objections from providing contraceptive coverage to their employees. And the court this term has again taken several religious liberty cases, including Fulton versus City of Philadelphia, which involves Philadelphia's decision not to use Catholic charities for adoption, given that they don't place foster children with gay or unmarried couples. And the justices in Fulton agreed to reconsider the court's 1980 decision, Employment Division versus Smith. That was a separate question presented in the cert petition. The court has already held this term in Tanzine versus Tanvir that government officials who violate the Religious Freedom Restoration Act can be held personally liable for monetary damages. So it is a hot topic at the court last term and this term. And the most exciting religious liberty case has probably been the Diocese of Brooklyn versus Cuomo, which was decided on the shadow docket. It was not a case that came up for certiorari, but one where the Supreme Court ruled on an emergency petition. And it was our case, led by our partner in New York, Randy Mastro. And it began with Governor Cuomo's response to the COVID-19 pandemic. He issued an executive order that capped attendance at religious services at 10 persons in the red zones and 25 persons in orange zones. And the Roman Catholic Diocese and 2 Orthodox Jewish synagogues asked the court to enjoin the order on the grounds that it likely violates the First Amendment. And as we discussed at the outset, this came up on the shadow docket, and it was a request for an injunction pursuant to the court's authority under the All Writs Act. And the court, in a 5-4 per curiam opinion, sided with the churches and the synagogues. And the court explained that Governor Cuomo's order did not appear to be neutral. Instead, it singled out houses of worship for especially harsh treatment. For example, while the synagogues and churches in red zones were limited to 10 people at a service, there were no limits on how many people at a nearby essential business, which could include acupuncture or a campground, anything. And in orange zones, attendance at houses of worship was limited to 25. Well, even non-essential secular businesses could decide for themselves how many to admit. And so because the order was not neutral, it was subject to strict scrutiny, and the court held that the order failed strict scrutiny because it was too broad. There was no evidence that these houses of worship had contributed to the outbreaks, and there were other less restrictive rules that could have been employed instead, such as basing the maximum attendance on the size of the facility. And it's important to note that the court flipped on this issue after the passing of Justice Ginsburg and her replacement by Justice Barrett. And I mentioned at the outset, this was Justice Barrett's first publicly discernible vote. A church in Nevada had challenged Nevada's restrictions on places of worship and had shown that casinos had remained open with people huddled around craps tables while churches remained strictly limited. And that, you would think, would be an excellent vehicle for the Supreme Court to intervene and strike down the state restrictions, but the case came out the other way, and there were, blistering dissents from the Republican-appointed judges besides the Chief Justice, who ruled with the democratically appointed judges. But Justice Barrett flipped the vote, and the Chief Justice was in dissent in the Brooklyn Diocese case. And Justice Gorsuch filed an appointed concurrence in this case, in which he stressed that even if the Constitution has taken a holiday during this pandemic, it cannot become a sabbatical. So classic Justice Gorsuch turn of phrase for you. Next slide, please. In the category of significantly less or significantly more boring, the Supreme Court in the Collins case is considering the constitutionality of the FHFA. And last term, the Supreme Court addressed the constitutionality of the structure of the Cfpb in the Celia Law case that I mentioned. And this is a similar companion case to the FHFA. And by statute, the Cfpb only allowed the director to be removed for cause. And the court stopped short of striking down the entire act in the Celia Law case, as the petitioners had urged the court to do. And instead, the court simply held that the president must be permitted to remove the director, even without cause. This term, the court considers that similar question. The FHFA was created by Congress in 2008 to act as a conservator for Fannie Mae and Freddie Mac, and again, it allows its director to be removed only for cause. So I think most court watchers predict a similar outcome. But there's another issue in the Collins case. In 2012, the FHFA amended its agreement with the Treasury Department so as to require Fannie Mae and Freddie Mac to pay dividends that are tied to the company's net worth, rather than the size of the Treasury Department's initial investment in the companies. And shareholders claim in this case that because the structure of the FHFA is unconstitutional, the property remedy is to set aside that entire amendment. They argue that there's no way to know who would have headed the FHFA over the years, or what policies those hypothetical directors might have pursued. And to complicate matters, the 2012 agreement was entered into under an acting director who could have been removed at will. So that raises a sort of harmless error argument. And it was clear at the oral argument that the justices they just did not really address the constitutional question, which makes sense given how similar it is to the CFPB. But what the justices really struggled with was the remedy. The vast majority of the questioning was centered on whether to invalidate the 2012 amendment. And interestingly, by the time the case arrived at the Supreme Court, the Trump Justice Department was not defending the constitutionality of the agency. And so the court appointed an amicus, a BYU law professor pictured on the slide here, named Aaron Nielsen, to defend the agency's constitutionality. And in one sense, Celia Law and Collins versus Mnuchin have little practical effect. They simply change the mechanism by which the president can remove officers, but they indicate a growing hostility by certain members of the court to the independence of the administrative state. And so they can be seen as smaller steps leading towards larger, more consequential issues like the Chevron doctrine. Next slide, please.
Actually, could we go back just one slide for a second? Just have a small side note here. You may have noticed some of these little sketches sprinkled in throughout the presentation. So For those of you who are regular, SCOTUS blog readers, you'll often see the advocates have sort of a watercolor portrait of themselves when they're advocating before the court, and they're sort of great souvenirs and mementos for the advocates. Obviously this year, because of COVID, the arguments have all been via audio. And so in lieu of that, I guess they still want to do some mementos. And so the official Supreme Court artist has been taking photos from the advocates. They've sort of taken a photo of themselves in their home offices, and they've been represented here. So you get sort of an interesting slice of people's home setups and an interesting artifact, I guess, from this strange time we're all living in. Anyway, just a fun aside as we continue on with our merits cases. So next slide, please. Okay, so next up, we have a pair of cases involving liability under the Alien Tort Statute. This is an important set of cases for corporate defendants. The Alien Tort Statute, for those who are less familiar, allows foreigners to bring lawsuits in US courts for serious violations of international law. It was enacted in 1789, but was largely dormant until 1980, when it was resurrected in a Second Circuit case, Philartigas. Since then, it has been used as a means of seeking compensation for human rights violations overseas, where multinational corporations have allegedly participated in those violations. In a 2004 case, Sosa versus Alvarez Machine, the Supreme Court held that liability under the ATS is reserved for a, quote, narrow set of violations of the law of nations. And the court has reaffirmed that narrowness several times since. The plaintiffs in these cases are citizens of Mali who claim they were sold as slaves to cocoa plantations in the Ivory Coast. They allege that the corporate defendants, these multinational corporations, aided and abetted human rights abuses because they, one, bought cocoa beans from those plantations, even though they knew that the plantations used child slavery, and two, provided the farmers with other support such as personal spending money and farming supplies. A federal district court dismissed the lawsuits because it found that the focus of the plaintiffs' claims was outside the United States. But the Ninth Circuit disagreed, reasoning that the defendants had presumably engaged in some of the activity, like the providing of spending money to the farmers, inside the United States. A number of the sort of more conservative justices on the Ninth Circuit filed what's called a dissental. So the defendants tried to have the case reheard en banc by a portion of the Ninth Circuit, and that request was denied, but a number of justices said that it should have been heard, and articulated obviously some of the positions advanced by the defendants here, for example, that the scope of the ATS is very narrow and was never really intended to apply against corporations. So some of these arguments are coming up obviously in the merits now before the Supreme Court. So there are two key questions in the case. The first is whether a, quote, aiding and abetting cause of action can be brought under the ATS and overcome the bar on extraterritorial application of law, where the company's alleged conduct arguably does not touch and concern the United States. The second question is whether the ATS can be applied to corporations at all. On the first question, the defendants argued that the conduct at the heart of the plaintiffs' claims, namely the purchase of cocoa, the alleged trafficking of the plaintiffs, and their forced labor, took place outside the United States, either in the Ivory Coast or Mali. The plaintiffs, meanwhile, argue that their claims touch and concern the US because all of the major decisions about the company's businesses were made domestically. On the second question about whether the ATS can be applied to corporations at all, defendants argue international law initially applied only to countries and then to individuals after the Nuremberg trials. They contest that it does not apply to corporations, citing a 2018 decision, Gessner versus Arab Bank, where the court held the ATS does not apply to foreign corporations. The plaintiffs argue, though, by contrast, that nothing in the text or history of the ATS suggests corporations cannot be defendants in lawsuits brought under the statute. At oral argument, several justices appeared skeptical that corporations should be wholly exempt from liability under the ATS, and those justices included Gorsuch, Kavanaugh, and Roberts. But they also seemed very skeptical that the allegations in the complaint were enough to survive the bar against extraterritoriality, and those justices included Kagan and Sotomayor. So, based on those lineups, some observers expect a fairly narrow ruling focused on the allegations in this particular complaint, or perhaps some law clarification on the law governing extraterritoriality. But it is possible, as articulated by some of the judges in the Ninth Circuit dissental, that the court may reach the issue of whether there's corporate liability at all under the ATS. And if it decides that there isn't, well, that would effectively end the use of this statute against corporations, although the plaintiffs may try another one, such as the Trafficking Victims Protection Reauthorization Act, to kind of achieve the same result. So it's possible that they'll just push litigation from one statute to another. So remains to be seen how that will shake out. Next slide, please.
Before I touch on this slide, I'll just answer a question that we received about Collins versus Mnuchin. And the question was, you mentioned that Collins might portend more aggressive actions by the court with regards to Chevron. Is there a particular case working its way through the system now that you think might serve as a likely vehicle for such a challenge? That's a really good question. And I'll point out that the court has actually rejected certiorari in a few cases relatively recently that would have given them an opportunity to, rethink Chevron altogether. There was a petition in October that the court rejected, brought by the Children's Hospital Association of Texas, that squarely presented whether Chevron should be overruled, and the court rejected it. We don't know why. It may have just been a bad vehicle, but the court has had the opportunity to do so and hasn't taken it. What the court has done is started to whittle away at it. So the Kaiser case from a few years ago was a closely divided decision with Justice Ginsburg on the bench, where the court refused to overrule our deference, which is agency readings of genuinely ambiguous regulations. So the court is trimming back the deference, but has so far hasn't addressed head on whether to overrule Chevron. So we will see in the years to come. Turning to these First Amendment cases, these are two of the more recent grants, really exciting First Amendment cases. One is Americans for Prosperity versus Becerra, and the other is Matinoid Area School District versus BL. And Americans for Prosperity arises out of two conservative political organizations' challenge to a California law that requires charitable organizations to submit federal tax forms to California that disclose the identities of their major donors. And these forms are not submitted publicly, but the plaintiffs claim that the California Attorney General's office has a history of disclosing the confidential material. And that whether inadvertently or through leaking, that's the allegation. And the donors whose identities have been disclosed have been subject to harassment and threats. And so the plaintiffs allege that the disclosure of the identities violates the First Amendment. And the law was actually enjoined by the district court and then reversed by the Ninth Circuit. And the principal argument by the organizations is that they speak on pretty contentious matters, and that when their donors' identities are leaked, they get harassed, and the result is chilling their speech, so that only the most stalwart supporters end up donating. And a group of Ninth Circuit judges dissented from the court's refusal to hear the case en banc, and they explained that the panel had used a watered-down standard of constitutional review that's applicable only in election cases, and that courts are supposed to review these sorts of disclosure laws under strict scrutiny. The Matinoid case arises out of punishment of a public school student who made an explicit post on Snapchat after not making the varsity cheer team. And she argues that her punishment violated the First Amendment because her speech was not on school grounds. And she prevailed at the Third Circuit, which held that public schools cannot regulate off-campus student speech. And this case will largely turn on a 1969 Supreme Court decision called Tinker versus Des Moines Independent Community School District, where the Supreme Court recognized that students retain First Amendment rights in school settings, but that schools are permitted under the First Amendment to discipline students whose speech would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. And so this case presents the question whether that standard also applies to off-campus speech. And the increase in social media, the new dynamics of the pandemic, bullying, and so many other things have made this a really important issue. And the case hasn't been briefed or argued yet, so it's hard to tell how the issues will percolate before the court. But you could see the court requiring some nexus to school proceedings for Tinker to apply, for example, It's hard to see the court totally preventing schools from regulating speech just because it occurs off campus. Next slide, please.
Okay, so next up, we have an important recent grant in the space of class action. So for those of you who find yourselves defending against class action cases, this is for sure one to keep a close eye on. We just have a few minutes left, so I'll go through it fairly high level. But the issue essentially is whether you can certify a damages class, B3 class, when most of the class did not suffer any injury, arguably, let alone an injury resembling what the lead class representative actually suffered. So by way of quick background, the plaintiff went to a car dealership to buy a car. When the dealership ran his credit report, it showed that his name was on a list maintained by the by OFAC of people who basically the US companies cannot do business with because they're suspected terrorists or other sort of nefarious persons. So this was, totally inadvertent, but this person went to go buy a car. This indication falsely appeared on his report. TransUnion, the company that had prepared the report, eventually removed the OFAC alert, but the plaintiff obviously claimed that the damage had been done. So he filed a class action against TransUnion, arguing that its actions violated the Fair Credit Reporting Act. The district court certified a class of everybody who, over a 6-month period, received a letter from TransUnion stating that their name was a potential match for somebody on the OFAC list. But only a fraction of those people actually had their credit reports sent to a third party, like Mr. Ramirez did. TransUnion, in its petition, argues that a class like this, where a majority of the class members did not suffer any injury at all because nobody ever saw these sort of false positive designations that they were on the OFAC list, cannot be certified, that they weren't injured, and certainly didn't suffer one akin to the named plaintiff who had a very different sort of injury where this information was publicly disclosed. And so they argue that such a class would violate both the Constitution and the federal rules governing class actions. So again, very important case in this area. The question of absent class member standing has been one that has been percolating through the lower courts for a number of years now, and we've been waiting for the court to issue some guidance on this point. So we're excited to see how this one comes down. It'll likely be argued in the spring. Next slide, please.
And the last case we'll cover is NCAA versus Alston. This case hasn't been briefed yet or set for argument, but it also will likely be argued in the spring. And the case is about Division I football and basketball players who sued the NCAA, claiming that the league's ban on non-cash education-related benefits like computers, science equipment, postgraduate scholarships, and internships, that ban violates federal antitrust laws, and the Ninth Circuit agreed. And sports leagues have for decades enjoyed a unique place in American antitrust law. College sports have been given leeway to impose restrictions that would otherwise be scrutinized because those restrictions are necessary to preserve the essential character and quality of college athletics. And in 1984, the Supreme Court decided a case called NCAA versus Board of Regents, dealing with television licensing. And although that case does not directly apply, the court indicated there that eligibility standards for college athletes are held to a less strict standard than in most antitrust cases. And the Ninth Circuit here held that the NCAA's restrictions were unlawful and that limits on paying college athletes were not necessary to preserve the distinctions between college and professional athletes. Court held that colleges could pay athletes as much as they want and not destroy that distinction because the payments would still be related to education. And the real complaint by the NCAA is that the district court engaged in a really searching scrutiny of the restrictions and the justifications rather than a very loose and high level review full of deference to the league. And the NCAA argued in its cert petition that the Ninth Circuit scrutiny is far more searching than what other circuits have conducted and what the Supreme Court required in the Board of Regents case. Before the Supreme Court, the NCAA argues that if allowed to stand, the Ninth Circuit's ruling would fundamentally transform the century-old institution of NCAA sports. It would blur the line between college and professional athletes. But for their part, the athletes argue that what the NCAA is really interested in is not tradition, but immunity from antitrust law. The athletes argue that this immunity is contrary to congressional intent, that Congress is currently considering whether to roll back limits on athlete compensation due to the profound inequity of a system that enables conference executives, athletic directors, coaches, schools, television networks, and a host of others to make billions of dollars on the backs of young, often underprivileged players. That's a direct quote from the athlete's brief. And so this is, needless to say, a very important case, touches on one of the most controversial issues in the sports world, and will definitely be one to watch this year. And I believe that's the end of the cases we had planned to cover. I think we just got the one question, so we'll end the presentation here. Please feel free to email Lauren or me, and we'll be happy to answer any other questions you have. But thank you for joining us today.